it's really important not just to focus on the moment when we don't have enough ventilators for everybody. We need to focus on the whole decision, and the decision not to have enough ventilators. That was a social decision, and it was a social decision from which disabled people disproportionately lacked input. I mean, this is essentially people without disabilities deciding at time one, well, we have better things to spend our money on than have a stockpile of ventilators. And then at time two, when we need to have more ventilators, saying to disabled people, hey, sorry, it's just how it is. We just don't have enough ventilators. Sorry, you have to pay the price.
Sam Bagenstos is Frank G. Millard Professor of Law at Michigan Law and one of the nation's leading legal experts on the civil rights of disabled people in this country. From 2009 to 2011, he was the Principal Deputy Assistant Attorney General for Civil Rights, which is the #2 position in the Civil Rights Division of the Department of Justice. He was kind enough to take some time to talk with us here at COVID Chat about a new article he has up on SSRN, and there will be links to that, and also complaints that he and colleagues in the disability community are filing to try to protect the civil rights of disabled people in this country as we are facing a public health catastrophe due to the reckless disregard for human life of the Trump administration. It was a really enlightening conversation. I hope you have time to watch it. And I really do thank Sam. He, again, is literally one of the leading experts in this area of law in the entire country. And I'm really grateful that he had the time to spend with us, because I know so many of us right now are deeply concerned about documents that we're seeing, rationing policies, like the document that came out last night from the Henry Ford healthcare system. And that's something that we also talk about. So without any further ado, here's the conversation. Sam Bagenstos, thanks for joining us. Really great to have you with us. I reached out to you when I saw that you put an article up on SSRN. May hospitals withhold ventilators from COVID-19 patients with pre-existing disabilities? Notes on the law and ethics of disability-based medical rationing. And I'm wondering if you can tell us a little bit about the piece. What prompted you to write it?
Well, what prompted me to write it was we are very close to a situation where there's going to be rationing of life-saving treatments, and in particular ventilators. I want to be clear, that's the result of a bunch of decisions that society has made over a long time, and I want to get to that later because that matters. I think people think about this as, well, we have no choice, and the fact is we did have a choice, and that matters. But right now we're in a place where there aren't enough ventilators to go around, or at least there may not be very soon. And so we've already seen in the plans of many states that as they prepare for this eventuality, a number of states are intending to deny ventilators and other life saving treatment to people who have disabilities that pre-existed coronavirus because of those disabilities, and that in my view is a violation of the ADA and other non-discrimination laws. I have worked with a number of advocates to file administrative complaints challenging that, and it seemed to me it was useful to have kind of a clear case for what the law means and why this is a violation of the law out there. So I thought it was important to write that and put that out there.
Got it. Let's get wonky for a second. So you mentioned the ADA. Your piece also talks about Section 504 of the Rehabilitation Act, and my favorite section of the Affordable Care Act, Section 1557. These are federal civil rights laws. It's an area you know something about, having been the #2 official at the Civil Division under the Barack Obama White House, back when working for the President of the United States was an enviable and prestigious and good thing to do with one's public service. Forgive the editorializing. Can you tell us a little bit more about those disability laws and why? I don't think people are going to make the connection between the Affordable Care Act and rationing a ventilator.
Mhm. Yeah, I mean, so the Affordable Care Act, as you point out, has this wildly underdiscussed provision, at least in public, Section 1557, which is a non-discrimination provision that applies to healthcare decisions, and it covers a lot of different bases, including sex, including race, including age, but it also includes disability. And it was important because, I mean, there are these pre-existing laws, the ADA, which applies to doctors and hospitals in both the public and private sectors. It applies to some extent to insurance companies, although there's a limitation there, and that creates a lot of problems. There's the Rehabilitation Act, which applies basically to all hospitals that get Medicaid, anyone who gets federal funds, which includes all hospitals that get Medicaid, which is most hospitals. But there were gaps in the coverage of those statutes in the healthcare system. And what 1557 essentially says is, throughout our healthcare system, I mean, it's a little more complicated than that, but throughout our healthcare system, we're going to apply these non-discrimination principles. And so it's become, one of the most significant provisions to challenge discrimination in healthcare by whoever is participating in the healthcare system. And all these statutes in this area are enforced by the Office for Civil Rights at the Department of Health and Human Services. And so that's why they're the central entity that we're trying to get to set some clear rules today, or very soon, about to make clear that rationing that's based on disability is not allowed by the law. Because once we get into a position where there's a doctor with two patients and they're deciding who to give a ventilator to, the fear is that judges are going to be very deferential to the doctors, because judges don't tend to stand up in a very heroic way in the midst of what they perceive to be a crisis. So we want the rules to be clear right now. As I've said to some people before, we're like at a minute to midnight on this question, and we don't want to be at 5 minutes after midnight trying to figure out what the rules are.
So let's talk about what your central argument here is. It's in the piece you're arguing, I think, if I'm following you correctly, that the rhetorical trick we're going to see is talking about who is qualified for life-saving interventions. And could you tell us a little bit about why qualified is important, why that's a key word here?
Yeah, and so, I mean, that is very wonky, but it's going to be the crucial legal fight. So what the disability discrimination laws prohibit is discrimination against qualified individuals with disabilities because of their disability, and that's the language that the laws use: qualified, or one of the statutes says otherwise qualified. And so, what does qualified mean? And what you're going to see a lot of medical providers say is, well, in a scarcity situation, what it means to be qualified for a medical treatment is that you're going to get the biggest benefit from it in one way or another, right? And so that seems to be the justification that is being offered for these protocols that have been adopted in a number of states that say, if you are in a world of scarce ventilators, don't give it to the person who has a developmental disability, which is an Alabama policy that we've challenged, for example, or don't give it to a person who has an underlying cognitive or physical impairment. And that seems to be about the notion that if you have one of these underlying impairments, either you won't live as long after you get healed from your coronavirus, after you recover, or the quality of your life won't be as good. And so, because of your disability, your underlying disability, your life will be shorter, or your life won't be as good. And our argument in these complaints, and my argument in this piece, which I hope that you also post with your viewers, is that where disability, and in particular disability other than the condition being treated, is a basis for a determination that someone's life is going to be shorter or of less quality, that's not something that can count as a qualification under the statute. Otherwise, what you're allowing the health providers to do is essentially justify their discrimination by discrimination. They're sneaking into qualified and the definition of qualified disability discrimination, which is something the Supreme Court actually a long time ago said you can't do. So, back in 1985, one of its first disability discrimination cases, the Supreme Court said you can't define qualification for the relevant benefit in a way that just excludes people with disabilities. Otherwise, it'd be too easy to evade the disability discrimination laws. Now, obviously, If there's no ability to benefit from the treatment at all, and that's connected to a disability, maybe that's something we might think of as a qualification. If someone is going to literally die tomorrow, someone has end stage cancer and is going to die tomorrow, whether they get the ventilator or not, that's not the case we're talking about. The problem with these protocols is they're drawing conclusions about the life expectancy or the quality of life of people with disabilities just based on their disability, not in this imminent setting, but over the long term. And we have such a substantial literature demonstrating physicians and medical professionals have bias about disability, both bias about the quality of life with a disability, but also bias about prognoses. And so, it's totally common to talk to someone who has a serious disability, or talk to the parent of someone who has a serious disability, whose doctors have said for years, oh, this person won't live another 6 months. This person won't live another 2 years. And so when we allow medical professionals to make determinations about quantity or quality of life that are triggered by disability, all we're doing is allowing them to pour their biases, which might be unconscious or implicit biases, into the decision. And that's what the disability discrimination laws are about stopping.
And and so you have, along with colleagues, if I'm getting this wrong, please correct me, but you've filed administrative complaints with an office inside of the Federal Health and Human Services Department called the Office for Civil Rights, OCR. Um, can you tell us what the thinking was about going to OCR right now with these complaints and what you hope to achieve?
Yeah, absolutely. The thinking was, we need to have clear rules of the road for healthcare systems before they're actually in a position of denying any particular person a medical treatment, for a bunch of reasons. I mean, one is the reason I talked about. When you're in this acute situation, it's really hard to get courts to stand up to professionals of any kind. Sometimes they will, but it's really hard to. So it's better to try to do this ahead of time, until you have someone who's actually been denied a ventilator. Then it's difficult to frame a lawsuit because it's hard to have a plaintiff for a lawsuit. So it actually, administrative agencies are in a much better position to deal with these issues prospectively. And when you can file a lawsuit on behalf of someone who was denied a ventilator, I mean, time is such of the essence. The person might actually die before you can have a temporary restraining order even decided. So we felt it was really important to get to the entity that could make an authoritative determination now, before, what could be in a matter of days. Honestly, we could be in this situation where people are being denied ventilators. And we already hear um, reports that we're following up of medical professionals encouraging their patients who have pre-existing disabilities maybe not to use the ventilators that they're using now, or in part because of a fear that the ventilators won't be available later, for coronavirus patients. So, already we're starting to see concerns about this. But once it gets to the point of somebody actually being denied a ventilator, it might be too late. And so we want to act now.
You started earlier saying something that I've been thinking a lot about, which is that if we don't have enough ventilators, it's not because of some law of physics that prevented us as a community, as a country, from producing enough ventilators. It really seems to be, if I'm understanding the situation, a condition of our own choosing. Do you think that's right?
I think that's exactly right. And you can even trace back, going through the public policy history here, even of the last few years, people saying we really need to stockpile ventilators because, yeah, maybe every day we don't need a lot of ventilators, but there are going to be surge moments where we're going to need them. And, folks saying, based on short-term thinking, well, we have better places to spend our money than that. And one of the points I tried to make in the paper that you talked about before, is that it's really important not just to focus on the moment when we don't have enough ventilators for everybody. We need to focus on the whole decision, and the decision not to have enough ventilators. That was a social decision, and it was a social decision from which disabled people disproportionately lacked input. I mean, this is essentially people without disabilities deciding at time one, well, we have better things to spend our money on than have a stockpile of ventilators. And then at time two, when we need to have more ventilators, saying to disabled people, hey, sorry, it's just how it is. We just don't have enough ventilators. Sorry, you have to pay the price. If disabled people were fully included in the decision at time one, probably we wouldn't have said we're going to underinvest in ventilators. But because they're not, you end up with a situation where essentially non-disabled people can shortchange public health and then offload all the cost onto people who are disproportionately underrepresented and in the process. And that's why we have civil rights laws, is to protect people against being harmed by political processes from which they're excluded. It's one of the core reasons we have civil rights laws. That's one of the, and the moment of adopting the ADA in 1990 was sort of a big moment where folks with and without disabilities understood, at least at a very general level, that we're all connected in some way. Disability is the one minority group anyone can enter into at a moment's notice. We're all going to enter into. Everyone will enter into if they're lucky to live long enough. And so mostly human psychology is such that people who don't have disabilities want to say, I'm very different than a person with a disability. This isn't going to happen to me. This isn't something I have to worry about. And what the ADA was is a brief reflection that actually we're all tied together. And the point of enforcing the ADA is to keep non-disabled folks who control political decisions from offloading the cost of those decisions on disabled people, essentially. And that's the big fear about what's happening here.
Exactly. And what that reminds me of is some of the questions and pushback I've seen and gotten myself from clinicians who are saying, this is battlefield medicine. We're in a triage situation. There are scarce resources. And as I've been thinking about this, it just occurs to me there's been no declaration of war. There's been, to the best of my knowledge, and this is an area where I am not as expert as some others, and so if I'm wrong on this, I'd be happy to learn it. But my understanding is that there is nothing that has happened in the last 2 or 3 months that has abrogated, that has paused or put on hold federal civil rights protections. Am I getting that right?
Yeah, I mean, so the federal civil rights laws are still there. They are fully in force, and they need to be enforced. And I hear this battlefield triage metaphor a lot too. That, well, it's just like on a battlefield. It's not that we don't respect the soldiers who we can't save. It's just we recognize we can't save everyone. We don't want to save one person and let 100 people die. And I think it's really an inapt analogy for a few reasons. So one reason is a lot of the time here, what we're talking about is not let one person die or let 100 people die. It's you have two people in one ventilator and you're deciding who's going to die. And even if we're at that moment, so forget all the decisions that led us here to not be able to save everybody. Even if you're at that moment, then the question is, well, how are you choosing between the two people? And all the ADA says, and these non-discrimination laws say, is disability. Your underlying disability can't be the basis you choose. There could be other neutral factors. So what a lot of people say is that what we ought to do is a lottery if we're in this situation. That would be fair to everybody. Anyone who would benefit from the treatment, you just do a lottery among them. And you know, if that strikes you as unacceptable, and I understand why, it feels arbitrary, then I think we have to recognize that that shows that we've been making a lot of very unfair decisions for a number of years and not investing in ventilator capacity. But again, once we've made those decisions to say it's disabled people who are going to bear the brunt, when you have two people, you can only save one. The argument that we should save the non-disabled person always over the disabled person because we think the disabled person won't live longer or won't live as good a life. Why should we do that, particularly given the biases in the healthcare system? So the other thing that makes this not like battlefield triage is in battlefield triage, we have no particular reason to believe that the medic on the battlefield, is undervaluing the injuries of one person or another, or the underlying conditions of one fallen soldier rather than another. Here, we actually have a very substantial empirical base to show that there is bias about the quantity of life, the life expectancy of people with disabilities on the part of medical professionals, and there's a very substantial bias about quality of life as well. And there's such a substantial difference. This has been shown over and over and over again. People who have disabilities report, on average, a quality of life pretty much the same as people without disabilities. People without disabilities, when asked to describe the quality of life with a disability, think the quality of life with the disability is really bad. And you see this gap over and over again. And my friend Liz Emmons at Columbia talks about this as the inside and the outside perspective of disability. And uh, what you're doing if you let healthcare systems decide, well, disabled people have a lower quality of life, therefore, in a time of scarcity, to do the greatest good for the greatest number, we have to save the non-disabled people, is you're just allowing them to implement those biases. And remember, the medical professions are professions that really, really underrepresent disabled people. I mean, so if you look at doctors, if you look at medical schools, if you look at other health professions, you see a substantial underrepresentation of people with disabilities. And that's really important as part of this as well.
So true. We've we see New York Times articles highlighting when there are public doctors who are disabled, doctors who are publicly disabled. That's how rare it is.
Yeah.
That all makes sense to me. The notion that people with, for example, intellectual and developmental disabilities would be undervalued, the quality of their life would be worth less in the eyes of some clinicians, seems fairly straightforward. There seems to me to be a closer question about getting back to this qualified language. We saw a letter from Henry Ford, a Michigan healthcare system, about underlying conditions that would mean that you are not qualified for ventilator care. And thinking about those sorts of publications from healthcare facilities and just what we need in terms of clarity, one of the conditions listed was terminal cancer, and I don't know what that means. I don't know if that means active cancer. I don't know if that means if at some point you were diagnosed with metastatic cancer, regardless of your current cancer status. And so last night when this letter came out, a number of friends in the breast cancer community reached out to me and said, "What does this mean? You're a lawyer, you should know." And I had to tell them I had no idea what they meant by terminal cancer. That wasn't a legal term I recognized. So are we hoping for some sort of further clarity from federal civil rights officials about what they need to communicate around these issues? Because it seems to me wiggle room is really not a thing you necessarily want to have for all of the reasons about bias and discrimination that you've articulated.
I totally agree. I mean, that's the concerning aspect in particular of that Henry Ford memo that went around, that, at first there was some doubt about his provenance, but they ultimately confirmed, no, this is their contingency plan. And you know, I think it's really important that, there's nothing in that protocol that says anything about non-discrimination on the basis of disability. They talk about non-discrimination on a number of other bases. They don't talk about disability, and I think that probably jumped out at you. It certainly jumped out at a lot of people who I've talked about that with. But I think also the vagueness of a lot of these terms, which, as you say, is exactly what invites bias. So I think you need to have something very clear, because otherwise people are going to look at that and say terminal cancer. Well, this is a condition that people don't live 5 years. That's not really saying you can't benefit from coronavirus treatment, right? I mean, you can live a good full life with your family and community for 5 years, and so I think it's really important to have some boundaries there, and that is one of the things that we're pushing on. Again, nobody's saying if someone is going to die tomorrow without the ventilator or with the ventilator, either way, that the ventilator has to go to them. But I think, once we start getting into this vaguer place where, we're just making assumptions about how long people can live over the longer term, that really is the place where the bias can deeply inflect the decisions.
Got it. Got it. Last question before we let you go, and we know you've got so much to do. Um, my understanding is that there's a federal law. I'm not an expert in it. It's called the Defense Production Act that would allow the President of the United States, if he so chose, to mobilize a whole of country response, saying to American manufacturers of medical goods and others like automotive companies, you are now in the business of saving American lives. You're going to get paid. The US government's good for it. Your workers are going to go to work. We're going to pay you whatever you need to pay to retool your factories. And we saw last night a story break that the Trump administration has declined to pay $1 billion. $1 billion. I know it's a lot of money to me. Might even be a lot of money to President Trump. Who knows? But it's not a lot of money in terms of the spending that we've seen Congress engage in terms of corporate bailouts. We've got a $500 billion fund for corporate bailouts in the bill, and it does include $1 billion for Defense Production Act purchases. As someone who his legal career is extremely concerned with civil rights, do you have any concerns about the President of the United States saying to American companies, actually, in this time of exigency, in this time of emergency, in this time of public health catastrophe, you're making vents now, you'll be paid. You can run your factories as you want on the ground, but these are your orders now. As someone deeply concerned with civil rights, do you see that as a civil rights violation?
To require them to do that? No, I don't think so. I mean, I think it's actually what we need right now to prevent maybe a civil rights catastrophe, honestly, and so it's really absolutely, it's absolutely depressing to read that article yesterday when it posted last night. We are in a situation everyone tells us is an emergency. The president seems to think because he walks into a hospital and sees only two ventilators in the entire hospital, that means we don't need ventilators. It actually highlights the need for ventilators at a surge time. It means we don't have enough ventilators. We know, I mean, every day you hear more and more from the people who are actually working in the wards of these hospitals. I hear from nurses I know. We're really approaching capacity, and what are we going to do? And, you know, we could avoid some of these very difficult and tragic choices if we would just commit the resources to build these ventilators. GM apparently was willing to do that and still appears to be standing willing to do that. And it was the administration that backed off, in part because of the price tag. $1 billion, when you think about the number of lives that would be saved by that, is really nothing. It's not something, as you say, it's like 1/500th of the tax giveaways in the bill that we're passing. It's really nothing in terms of the lives we're going to save. And yeah, that we can't commit to that, it makes this not just a tragedy, but a travesty.